Welcome, curious minds, to another deep dive. Today we're embarking on a fascinating journey into a really pivotal moment in Florida's open government landscape. Whether you're already deep in the weeds of Florida's public records laws or just curious about how these transparency battles play out, this case, well, it offers a truly insightful look. We're going to dissect a specific appellate court decision from 1976. It brilliantly illuminates the interplay between public records, labor relations, and fundamentally the right to know.
That's right. This case, Warden v. Bennett from Florida's 2nd District Court of Appeal, it's really a masterclass in how different laws get balanced under the Public Records Act. It's not just about what records are public, but digging into the why and the how access can, or maybe sometimes cannot, be limited. And, to really get its significance, you have to remember that back in '76, public sector unions and these related labor laws in Florida were still pretty new territory. There was quite a bit of legal ambiguity, sort of, about how these new rights would mesh with existing transparency laws. This case was right there at the forefront, defining that relationship.
Okay, so let's unpack this then. What's the core scenario we're diving into here? Who were the key players, and what exactly was at stake for them?
Well, the central figure was a citizen named Warden. She was also a labor organizer for the Communication Workers of America, and she brought a lawsuit against Bennett, who was the president of St. Petersburg Junior College at the time, and also against the college trustees.
Okay, and what specific information was Warden trying to, well, get her hands on from the college? What was the goal?
She wanted two very specific things. First, the names and addresses of all the college employees, and second, copies of the working papers, the documents used in putting together the college budget. And crucially, she was very open about why. She admitted her purpose was to use this information to help organize the college's employees.
Right, a very clear intent stated up front. So how did the first court, the Pinellas County Circuit Court, react to that? How did they rule?
The circuit court actually dismissed Warden's petition completely. They basically concluded the college wasn't legally obligated to provide these records. They sided with the college.
But hang on, this wasn't really about whether these were actually public records, was it? I mean, the appellate court pointed out some things weren't even in dispute.
Exactly right. The appellate court specifically noted that nobody seriously suggested these weren't public records under Chapter 119, Florida's Public Records Act. They even cited an earlier case from '74, City of Gainesville, just to reinforce that baseline understanding. And there was no claim that giving the records would mess up college business or that Warden wouldn't pay the copying costs. No, the whole fight was purely about the reasons the college gave for saying no.
Okay, and this is where it gets really interesting, because the college had, well, several reasons, and the lower court bought them. 4 distinct grounds. Let's take them one by one. How did the appellate court start picking these apart? What was argument number one?
The first ground the lower court relied on was public policy. They felt that a part of the Public Employees Relations Act, PERA, that's in Chapter 447, says the state should be neutral, neither encourage nor discourage union organizing. So the lower court figured providing these records would improperly help Warden organize, violating that neutrality.
Huh. So providing records required by one law somehow meant taking sides under another law. That seems a bit of a stretch, doesn't it? Especially for transparency. How did the appeals court handle that point?
Yeah, the appellate court seemed to find it difficult to comprehend, frankly. They stated pretty clearly that just furnishing public records, which Chapter 119 mandates, simply could not violate the spirit of Chapter 447. And maybe most importantly, the Public Records Act doesn't care why someone wants the records. Warden's reason wasn't illegal. Organizing is perfectly legal, so her intent was deemed totally irrelevant to her right to access.
Okay, so motive is irrelevant. That's a huge principle right there.
Grumpy.
The college wasn't done. They had another angle. What was the second argument?
Their second argument was, well, that by providing the records, the college might be committing an unfair labor practice. And because of that possibility, they argued Warden should first have to go through the administrative process with the Public Employees Relations Commission, PERC, under Chapter 447. It's a classic move, really. Wrong venue. Go talk to the labor board first.
Right, that sounds familiar. Delay tactic, maybe. What did the appeals court say about this idea of having to go through PERC first?
Well, the appellate court actually referenced one of its own rulings from earlier that same year. They'd already basically said that providing records because the law requires it couldn't possibly be argued as an unfair labor practice. It's just following the law. In fact, they cheekily noted that refusing to provide the records might actually be closer to an unfair labor practice. And critically, there's absolutely nothing in the Public Records Act that says a citizen has to go argue about unfair labor practices before they can get public records.
Okay, that makes sense. Now, this next point touches on something we hear a lot, the idea that if information is available somewhere else, maybe through a different channel, you have to try that first. That was the third argument, wasn't it?
It was, yes. The third ground was that making the college give the info would bypass the whole collective bargaining setup and contradict a specific PERC rule, Rule 8H3.27. And that rule details how an eligibility list, names and addresses, gets filed, but only within 10 days after a union election is approved or directed.
So the argument was, look, there's a process to get this later, specifically for elections, so you can't use the General Public Records Act now.
Exactly. But the appellate court called that reasoning fallacious, flawed. They were very clear. The Public Records Act has zero requirement that you first prove you tried and failed to get the info elsewhere. It's just because it might be available somewhere else someday. Plus, and this is important, that PRC rule only gives names and addresses after an election is basically underway. That's a very specific, limited situation. It doesn't cancel out the general right to access under Chapter 119. It's not an either situation.
Right. One specific process doesn't negate a general right.
Right. Yeah.
For the fourth and final argument, the lower court accepted. What was that?
The fourth one was really broad, just a flat assertion that the right to get information under the Public Records Act simply has to yield, has to give way to the whole system set up for regulating public employee labor relations in Chapter 447.
Wow. So basically, Chapter 447, the labor law, just trumps Chapter 119, the transparency law, across the board.
Yeah.
That was the implication.
That was the implication, yes. But the appellate court found absolutely nothing in Chapter 447 to even remotely suggest that. Nothing that said records normally public under a 119 shouldn't be given to people organizing employees. And here's the really clever part of their reasoning. They pointed to a specific section already in the law, Section 447.6053. That section explicitly exempts work products developed by the public employer in preparation for negotiations and during negotiations from Chapter 119.
So the legislature knew how to create an exemption when they wanted one. That's a powerful point about legislative intent.
It really is. The court's logic was simple but strong. Look, the legislature specifically carved out this one thing, negotiation work products. The fact they didn't exempt anything else, like employee lists or budget papers used for organizing, strongly suggests they saw no other conflict between the two laws. If they wanted other stuff secret, they would have said so.
Makes perfect sense. Now, before they wrapped it all up, the court did mention one specific point that gave them pause. A moment of doubt, I think they called it. What was that tricky bit?
The only real hesitation the appellate court expressed was about the addresses of the college employees. They wondered if addresses could be considered part of confidential personnel records, based on an earlier case, Wisher v. News Press Publishing Company from 1975. You know, the Wisher case had established some confidentiality for personnel files to protect employee privacy.
Right, the Wisher case, protecting sensitive stuff in personnel files. So how did they resolve that specific question about addresses in Warden? Were addresses considered too private?
Well, they acknowledged that, yeah, sometimes an employee might want their address kept private, but they also noted, realistically, it's pretty rare that a public employee's address isn't findable through other public sources anyway, even back then. So the court reasoned, an employee's actual expectation that their home address is truly private and unascertainable is probably minimal. And importantly, they also recognize there are legitimate public interests in knowing a public employee's address, things like accountability, communication.
So balancing those factors, the scale tipped towards transparency for addresses too.
On balance, yes. The court concluded that employee addresses do not fall under the confidentiality umbrella set up by the Wisher case for personnel files. They nailed down that point, preventing what could have been a kind of backdoor exemption. The focus remained on that minimal privacy expectation versus the public interest.
Okay, so after methodically taking down all four of the lower court's reasons and dealing with that final doubt about addresses, what was the ultimate verdict from the second DCA in Warden v. Bennett?
The court held definitively that President Bennett and the college trustees were obligated by the Public Records Act to give Warden all the information she requested, names, addresses, budget papers. The lower court's decision to dismiss her case was reversed, flat out.
And thinking about the impact, what really changed in how Florida approaches open government because of Warden v. Bennett? What's the lasting principle here?
I'd say this case really cemented what we often call the presumption of openness in Florida law. It made it crystal clear. Public records are public by default. The burden isn't on the citizen to justify why they need something. No, the burden is squarely on the government agency to point to a specific, explicit statutory exemption if they want to withhold something. Before Warden, maybe there was more wiggle room for agencies to make these sort of subjective public policy arguments like the college tried here. This ruling really shut that down. It established transparency as a legal starting point, the baseline, not something you had to argue for unless the legislature explicitly said otherwise. It's foundational.
A deep dive indeed. That clarity is really striking how the court reinforced the Public Records Act's strength, even when rubbing up against other laws like labor relations. It's such a powerful reminder, isn't it, about that fundamental principle of transparency in Florida government.
Absolutely. It exemplifies the kind of careful legal thinking needed when access rights intersect with other complex areas. It remains a vital touchstone for anyone working with the Public Records Act in Florida today.
So, thinking about all this, what's one lingering question or thought that this deep dive sparks for you? Something provocative related to this case's legacy, maybe?
That's a good question. I guess for me, it raises this. Given how much technology and our ideas about personal privacy have changed since 1976, how might a court today analyze that concept of a minimal expectation of privacy for a public employee's home address? Would the balance still tip the same way? It's definitely something to mull over in our current digital age.
That's a fascinating thought. And that is all the time we have for this deep dive. We really hope you feel even more informed now about this crucial piece of Florida's open government history. Until next time, keep digging for knowledge.